everyone. Good evening, ma'am. A very warm welcome to everyone on behalf of Nalsar's Nyaya Forum. Nyaya Forum is a student-run initiative devoted to research and advocacy on issues related to litigation and the judiciary as two parts of courtroom lawyering. As a part of a webinar series on the practical aspects of litigation, we are delighted to introduce our speaker for today, Ms. Swathi Sukumar. Thank you so much, ma'am, for joining us. Ms. Swathi is a litigator with 15 years of experience in intellectual property dispute. She is an alumnus of Nalsar University and Columbia Law School. She is ranked by Chambers and partners for her expertise in IP litigation and has been a counsel in several landmark IP disputes representing clients before various courts in India. So for today's session, it will be on patent litigation, a hypothetical patent dispute between Carimo and Invido Pharma was shared with all the participants and draft plaints were invited. Thus, today's session would basically focus upon that. One point of housekeeping before we begin. Since we want it to be an interactive session, we encourage everyone to participate and click on the raise hand option whenever someone wants to speak and join the discussion. If any one of you have any questions during the session, please feel free to type in the chat box and we will take them towards the end. So, ma'am, with that, I think we will start the session.
Great. Can everyone hear me? You can hear me, Gayatri?
Yes, ma'am.
Okay, great. Thanks a lot to Nyaya for organizing this. It feels really good to be working with Nalsar, of which, as Gayatri mentioned, I'm an alumnus, batch of 2005. Feels like yesterday, but it's been 15 years, sadly. So I'm really happy to be here. One of my favorite areas of IP law, even when I was in college and subsequently, has been patent litigation. And while I was interested in it, I did some moot court competitions when I was in law school, but it was just not the same thing once I graduated and I got to draft my first patent lawsuit about 1 month into practice. And it was, I think that case is still pending. So it was a real learning experience. And I realized what a distance one has to travel from being a student of law to actually being in practice. So I thought this session was a good way for me to share some of the experiences that I gained while learning the practice of law. And I wanted to share that with you. So I've received some claims, nowhere as many as I'd imagined, but I've had a chance to review these claims. And I think what I'll do is, instead of going through them kind of issue by issue, I'm going to broadly outline what I think you should keep in mind while drafting a patent lawsuit. And then we can take questions after each, maybe after each 10, 15 minute segment. So I can hear from you whether there's anything that needs clarification. So let's start with this. As all of you will know, patents are a statutory right. It's different from copyright in the sense that copyright exists whether or not you register. Patent rights are entirely statutory rights. That's step one. Second is, I think before you start drafting a plaint in any area, the first question you need to ask yourself is, what is it that you're trying to do? And that will directly impact how you tell the story that your client needs you to tell the court. So the first issue is, what are you trying to do? Remember, you're trying to get relief for your client. You're trying to get very particular relief, whether it's injunction or damages from the court. So that is really your focus, that you need to satisfy the legal requirements of pleading, and you need to, within the legal framework, fit in appropriate facts. So do all of you have, Gayatri, does everybody have the hypothetical before them, or should I share it here during the course of the call?
Ma'am, I think sharing would be okay. We have sent the hypothetical to everyone, but I don't know if people have it with them.
So it might be good to open it up because there's a reason why those facts were given. Because if you notice, there are a lot of facts there that are kind of meandering, that it doesn't really, it won't really compute why it was put there in the first place unless I put it in context for you. So I'm just sending on the Zoom call the hypothetical. So do take a look. Okay, now how do I send an attachment on this?
Ma'am, if I screen share, then your video would be off. I can do that if that's more appropriate.
Okay, so I can do it on
Or you
screen
can
share.
screen share.
Oh,
Yes, ma'am.
sorry for everybody else who's waiting on the call. There are some advantages to being born in the 1980s. This is not one of them. Hold on. Okay. So let me do a screen share. Okay, so do you have the patent dispute hypothetical in front of you?
Yes, ma'am.
Okay. So I think the first question while drafting a suit is who should be parties to this litigation? From the plaints I've received, most people have made Carimo the plaintiff, as they would be, and only Invido the defendant. Some others have made Jacinda the inventor defendant. Now, the cardinal rule is when you don't add somebody as a defendant to a proceeding, when you ought to have added them, you are barred by a provision, Order 2, Rule 2 of the Code of Civil Procedure from bringing a fresh suit against them. So who, in my opinion, should be the defendants? Invido, but also Baba Bimp, who was my distributor, who was distributing the infringing products despite knowing about the existence of my patent. So that is the reason why I put in the hypothetical, the conversation or my inability to reach Baba Bimp. It's important to make them a party to this because, as you will see from Section 48 of the Patents Act, anybody who sells, offers for sale, or advertises your product, advertises an infringing product, they would be violating your patent. So it is important to add Baba Bimp as one of the parties. It is not important to add Jacinda as a party because, as the proposition states, she has already assigned her rights to you. No rights survive in her hands, so to speak. So it is not important to add her, although you can add her as an employee of Invido who knowingly has violated your rights. She is not a necessary party, she is a proper party. So in any civil suit, the question you'll ask yourself is who are the necessary parties without whom the relief that is being sought cannot be granted, and who are proper parties. So in my mind, the necessary party is Invido, but Baba Bimp, provided you want to seek legal redress against them, Baba Bimp would be a necessary party and Jacinda would be a proper party. So this is as far as the parties are concerned. Now, when you're drafting a plaint, you are not just telling your story as you would do in a moot court, because I noticed that a lot of the plaints I received were in moot court style. You know, there's a statement of facts and there's some kind of general dealing with the law. That's not good enough. Actually, you have to build a much more of a story. And most importantly, when you're drafting a plaint, please try to foreclose the main defenses that a defendant is going to raise. What are the main defenses in law, right? First is non-joinder of necessary parties. Second is limitation, the issue of limitation, which again, I didn't see that anybody had dealt with it. Now, the dispute says, the hypotheticals mentions that you knew in 2015 about the existence of Invido. So today you're in 2020, and for most civil cases, the limitation period is 3 years. So the first question you should ask yourself is, how am I going to overcome this challenge? What was I doing since 2015? So how do you extend limitation? That's the first question you should ask yourself. The second question you should ask yourself is how, if they have made only 1.5 crores and the pecuniary jurisdiction threshold is 2 crores of the Delhi High Court, how am I going to make sure that I can make out a case for invoking the pecuniary jurisdiction of the High Court? For a moment, assume that there is territorial jurisdiction. How are you going to invoke the pecuniary jurisdiction of the Delhi High Court? So these are two very important points, because if you don't deal with these in your plaint, what will happen is on day one, when you stand up to address the court will not just not be convinced that you have a case of injunction, but may ask you this very fundamental question, which will leave you feeling embarrassed. So you must, whenever you're drafting a plaint, you must imagine, or you must have a clear idea of what are the weaknesses in your case that you need to overcome in the plaint itself. I don't mean that you need to imagine every defense that a defendant can raise. That is a recipe for disaster. But do respond to the main legal issues that arise in any civil suit. So first, to speak on the issue of limitation, right? So as far as intellectual property cases are concerned, courts have held that when a defendant continues to infringe, it constitutes a continuous cause of action, and every fresh infringement every day gives rise to a fresh cause of action, right? So you do have a continuous cause of action. So there's an easy way to get around the limitation period. But you need to have a separate paragraph saying that the plaintiff found out in October 2015 that they were selling this product. We wrote them a letter because at that time they were no threat to our business, but now they have expanded and they're approaching our clients. So although we knew about them in 2015, the cause of action is a continuous one and continues to subsist until the court passes an order restraining them. So you need to deal with the limitation aspect upfront. Second thing, as far as pecuniary jurisdiction is concerned, this is a slightly easier problem to solve. That you will say that although in 1 week they've made 1.5 crores, I am now today 1 month after this patent hypothetical. So they've already, in my estimation, made 6 crores, right? So I have crossed the pecuniary jurisdiction limit. Now assume that after earning, so this is one way that you will accumulate all the amount and you will say, look, I think they have earned 6 crores, but I don't really know. I need to find out at the end of the case. So give me time till the end of the case to assess exactly how much they made out of this product. And I estimate that it's 6 crores, which is certainly above 2 crores. So that's the first method. Now assume a slightly more problematic thing happens where after 1 week, they shut down their operations. So the only amount of money they've made is 1.5 crores as far as you know. So how do you bring the valuation up to 2 crores? Now, to do this, what you'll have to do is you'll have to say, actually, you know, my permanent injunction is worth 1 crore because when I get a permanent injunction, it will dissuade other people from infringing my patent. So actually, my damages claim is only 1.5 crores, but actually my permanent injunction is worth 1 crore to me and I will pay court fees on that 1 crore. So these are two ways in which you can go about it, but you do need, I didn't see it in any of the claims, you need to value your relief so that it meets the 2 crores threshold. Right? So these are two issues that you will encounter upfront, which you need to deal with. And secondly, as far as the issue of valuation of claims are concerned, the question is, can I value my IP at any rate I want? Suppose when I'm filing a claim, I have a copyright on a book, okay? And today somebody has sold it on, somebody has advertised it on Instagram, right? And has probably sold 1 copy. Can I value that relief at 2 crores? And you would be surprised that the answer is yes, you can. Because because courts have held that as a plaintiff, I'm entitled to arbitrarily value my relief, right? As long as I can make it good at the stage of trial, right? So at the first instance, you don't need to exert yourself, but valuation is important because you need to cross the pecuniary threshold, but also you need to pay court fees on whatever amount you value your claim at. So that is why you will have people who just value claims, like if the jurisdiction threshold is 2 crores, they'll value it at 2 crores 100, right? Because later, once you find out that they've actually made more money, you can change the valuation paragraph. So I urge you to think about 3 things, like I said, to recap. Who are the parties? Am I meeting the jurisdictional requirements, territorial and pecuniary? And am I meeting the limitation requirements? If I have any doubt on any of these 3, I need to address them up front in the plaint. Right. So, any questions on this?
Ma'am, till now we don't have a question.
Great. Okay. So I've covered who the defendants should be. Now let's go to the prayers, right? Now, what do you need to ask for in the prayers? Yes, a permanent injunction, but permanent injunction against what? Permanent injunction against infringing your patent in any way, including by the manufacturer of the product named Kokosha. Now, the reason it's important to particularize is often you'll have defendants saying, no, your prayer says that any product infringing the patent, I don't infringe the patent. So it's an argument that's trying to be too smart, but sometimes it works, right? So it's important to also mention in the prayer the infringing product against which you are seeking relief. Then you will ask for damages and rendition of accounts. Now, as far as damages is concerned, I mentioned to you that your damages can be based on several different facts. Your damages can be based on lost profit, on a reasonable royalty rate. Usually, it's one of these 2 things in patent cases. And you can also ask for rendition of accounts. Now, what's the difference between damages and rendition of account? Damages is you are valuing the claim upfront. Rendition of accounts is you will say that later when the defendants render accounts, then you will figure out how much they owe you. Now, the tricky thing about rendition of accounts is generally you should prove what is the rate you're asking for, right? So if I'm asking for $4 as royalty per DVD player, I need to put that in the claim, or I need to put it in my evidence that I need to prove at the stage of evidence that somebody is paying me $4. So that at the stage of rendition of accounts, the court says, okay, you have proved that you are owed $4. Now let's see how many they've actually manufactured, right? So there are these are two alternative routes, mind you, damages versus rendition of accounts, but you can add them both in your prayer and choose one of the two at the stage of evidence. So you can have both at the same time in your claim, with the understanding that by the time you reach trial, you need to have figured out whether you're going down the damages route or you're going down the rendition of accounts route. Now, as far as the damages are concerned, I had expressly put in the hypothetical that you need to look at section 111 of the Patents Act. Now, the reason section 111 is important is in patent cases, you cannot get damages if you don't prove knowledge, right? So you need to spend some time putting into your plaint at least 2 or 3 paragraphs on why the defendants had knowledge, and the fact that you sent them the legal notice in 2015 is a good ground. Then you will annex the delivery receipt to show that they got it. Now, because they had knowledge, the date on which you start calculating damages runs from the date that they had knowledge. So the date of their knowledge is very, very important. Often what happens is if you don't have any correspondence with the defendants, you might argue that I've published the patent and that's good enough. And yes, maybe, but they could also show that they have no knowledge. So it's always better to have a positive statement of how you think they had knowledge. For example, if Invido had in the meanwhile filed 6 patents, you can say they're obviously people familiar with the patent publication system. So it can reasonably be assumed that they knew of your patent, right? Despite this, courts sometimes will grant damages only from the date that you filed the suit, right? So this is something that you have to deal with in the plaint. And this is obviously highly dependent on the facts. So there's no one rule that will fit all situations. But in general, keep in mind that unless you show knowledge, there are going to be no damages awarded in your favor. So knowledge is an extremely important part of how you reason out your prayer. Then the most important thing in a patent plaint is claim comparison. For those of you who've gone through the Roche versus Suppler decision of the division bench of the Delhi High Court, you need to do a claim versus product comparison, right? Now, this would be, you've seen the claims that I've set out in the proposition. So you will need to, ideally, what I like doing personally, this is a habit, and it's kind of a good practice, is that have a tabular representation. 1 or 2 of you have done that in your claims. Have a tabular representation on the left side, reproduce your claim, right? And on the right side, you will put the infringing components to show that there is a match. And you'll have to show an exact match, right? So a lot of times what people do, and this is wrong, wrong practice, is that they compare a plaintiff's product with the defendant's product. So if you have Kyclean, they'll compare Kyclean with Kokosha, but that's actually a wrong comparison. The correct comparison is always between the claims as contained in your patent versus the infringing product. Is your product relevant? Yes, maybe it is relevant to calculate lost profit on the sale of your product. But the primary way to compare is to compare each element of your claim with each element of the infringing product. Generally, to show that you had conducted this exercise, you would file an expert affidavit to show that somebody actually went through the pain of comparing this product and figuring out that this falls within the parameters set out in your claim. Now we come to sticky territory when it comes to just replacing glycerin with coconut oil, right? They are equivalents. But how do you show that they're equivalents? You have to spend time, again, preferably through an expert report, but you'll have to labor, you'll have to spend at least 2 to 3 paragraphs on explaining why coconut oil is a mere substitute for glycerin. You might look at other compositions where coconut oil has replaced glycerin, or you might look at scientific literature that says that coconut oil is a perfect replacement for glycerin. But you have to show that coconut oil replacing glycerin does not affect the inventive step, right? So you have to identify what is the inventive step in your patent, and the inventive step in this patent would be combining these various components into a stable, marketable commodity, right? Because I can throw in a whole bunch of components, it may not be stable. So stability might be something that is an inventive step, that you have figured out the exact composition and you have figured out the exact proportion of each component to arrive at a stable, marketable commodity. And that is really the inventive step. I'd also thrown in some stuff on your charitable activities in your R&D. That's good background because, like I said, when you're drafting a plaint, you are telling a story, right? You are telling a story about an innovative company that has been swindled. You're telling a story about somebody who has been shortchanged by their ex-employee who assigned the rights to them. You're telling a story about somebody who's charitable, who's given to government, who is, distributed all these free samples, despite which this is happening to them. It's very important in a plaint to build in the story of innovation into it so that it's something that's easy to read. So I've covered so far the claim comparison aspect, and now the formal paragraphs. Most of your plaints didn't have formal paragraphs. Just one person who is a practicing lawyer, she sent me a plaint with formal paragraphs. Now, what are the formal paragraphs? The first paragraph, you will have to talk about, who is the authorized signatory, what is the constitution of the plaintiff, and you will have to prove that the plaintiff has authorized the authorized signatory. Then you will talk about the defendants and the constitution. Then you will have your paragraphs of facts where you narrate the background of the client, the amount that they've spent on research and development. Then you will talk about the claim comparison, and you will also in some way deal with the prosecution history of the patent. Right? Now, what is, sorry, I have a question. Let me take that first, and then I'll come back. Gayatri?
So should I take
Yeah,
the
you
question?
can unmute them.
Right. Samruddhi raised her hand. If we can unmute her.
Yeah.
Ma'am, actually, it was with regards to, hello?
Yeah, please tell me, Samruddhi.
Yes, ma'am. Actually, I had a doubt. I did not understand the difference between damages and rendering accounts when you had explained it earlier. But you can explain it later, ma'am. I mean, I did not want to interrupt while you were
No
explaining
problem.
something.
I'll just flag the question and I'll come back to it. Is there any other question? Because I don't want to just go ahead presuming everybody's gotten everything. Is there any other question? I've noted this one.
So, ma'am, there's one question regarding assignment. Tushar Shinde has asked, if there is an issue with remuneration, will the assignment still be valid?
Right. Very good question. Okay. So remuneration and what was the other one that, okay, rendition of accounts. Okay. On the issue of remuneration, I'd thrown it there to, for precisely this reason. Generally, your terms of assignment between an employer and employee are absolute. So you don't have to worry about remuneration becoming an issue as long as there is no lawsuit to set aside the assignment deed, which in this case, the facts don't reveal that there is, right? And generally, a patent is owned by the person who files it, right? And in this case, the patent has been filed by the person, has been filed by the company. So you don't have to worry about that. But that's a very, very good question. It can become an issue, and it has in many cases. And in India, because we have the first to file rule, we're not overly concerned about the interstate dispute between the inventor and the company. Yeah?
Yeah, those are the questions for now.
Okay, I've got one more question. That's just that's it?
Yeah, there's just one question which asks, what exactly does constitution of the plaintiff/defendant mean?
Right. So constitution means, are you a partnership? Are you a company? Are you an individual, right? If you are a company, then under the Companies Act, you have to have a particular way in which you authorize somebody, because so it's a very, very important question in any suit. What is the constitution? Is the plaintiff a company? Okay, then has the company authorized somebody? Is the defendant a proprietorship, a partnership, or a company? If they're a partnership, are they a registered partnership or an unregistered partnership? If they're an unregistered partnership, does the other partner has the other partner given you consent? So this is what you mean by the constitution of the defendants, and it's very important for in any case to understand the constitution before you file the case, right? I am, for example, facing a situation today where I had filed a trademark case before the Delhi High Court last week, right? And I filed the case against a company based on the Ministry of Company Affairs website. The defendant comes and says, well, the company is almost liquidated, but I'm running a proprietorship by the same name. And this means now that I have to bring the proprietor on record, because if I don't do that, I can't get effective relief against this infringer, right? So the constitution of the plaintiff and the defendant are both very, very important issues. If you don't know about the constitution of the defendant, it's worth spending time on the Ministry of Company Affairs website, right? Or purchasing that product and seeing who actually sells it. But you need to have some idea whether the defendant is a company, a partnership, or a proprietorship. Okay, I have another question.
Should I unmute the speaker?
Yes, please.
Doing it. Rahil, please go ahead.
Yeah. Ma'am, I just wanted to ask, what are the possible claims that...
I can't hear, Rahil, I can't hear you. Could you speak up?
Hello.
Yeah.
Am I audible now?
Yeah.
Yeah, ma'am, what I wanted to ask was, what are the possible claims that plaintiff can have against Baba Bimp? Should the distributor be aware of its patent and therefore should refrain from dealing with any competing producer, or what exactly will the plaintiff want to claim against the distributor?
So at the very least, you'll want a permanent injunction against your distributor selling this product to anybody, or to deal with infringing copies. Whether or not you get damages against them will depend on whether you're actually able to show knowledge of Baba Bimp, of the existence of your patent. But at the very least, you should ask for a permanent injunction against Baba Bimp, because you want them to stop selling the infringing product, right? So there are two things. There's the act of sale and there's knowledge. Just the act of sale or offering for sale is enough for a permanent injunction claim, but actual knowledge needs to be shown for a damages claim. Now, up front, you don't lose anything by asking for damages as well. You might not get damages, but ask, right? You can add the claim of damages against Baba Bimp as well.
Ma'am, so a small follow-up. How often do you think such damages are procured from such third parties? As in, how easy is it to demonstrate intention of violating a patent from such distributors?
Courts have been granting damages left, right, and center, assuming knowledge at least from the date of filing the suit, right? Because when you file the suit, they serve to the papers, then they know at least of your patent, right? So at least for people who you can't prove actual knowledge, the courts will assume that they had knowledge from the date that they were served with summons in your suit.
Right.
And they are granting damages.
Okay, thank you.
Another question, Gayatri?
No, ma'am, no more question. We can continue.
Okay, so this was a summary of what you needed to do. Now, as far as, please expect that as soon as you file a patent case, you are inviting a counterclaim for revocation, right? It's almost automatic. Now, why is it that there is a counterclaim for revocation? Because there are judgments that have held the minute the patent's validity is under doubt, courts will not grant an interim injunction. Now, bear in mind that in a lot of IP cases, a lot of property cases as well, your first injunction hearing is the key hearing, right? That is the day on which you can really, put the defendants in a bargaining power that will get them to settle, get them to give up. So a lot of time and money and a lot of the court's time, the court's resources are spent in hearing interim injunction hearings in patent cases, right? And courts have taken two views. The first view is that, look, we can't actually get into the composition of your product versus the composition of their product at this stage, because we need the experts to tell us and we need your experts to cross-examine each other. So we're actually not going to decide it right now. We will expedite trial and you go to trial and you come back. So that's one view. The second view is that look, if we do that, you are going to spread this product far and wide. It's going to cause irreparable injury to the plaintiff, because if my patent is violated today, nobody's going to license it from me, right? They just take a risk. So I'm going to lose a lot of revenue. And this is clear enough. I mean, this is just 4 components, germicidal components, and alcohol, glycerin, and fragrance. It's not so difficult for us to understand it. So we will do it. So these are 2 views. Now, the problem with something going into trial is that it's a very long haul process, right? Not to say that you can never expect a decision after trial, but there can be a lot of dilatory tactics adopted by the defendants. So a plaintiff has to work really hard to make sure that trial is concluded on time. You might have heard of this very famous cancer drug that was in the news in 2008, erlotinib mesylate. So that was a cancer drug manufactured by Roche, which Cipla was selling. And at the first instance, what happened was that Roche lost the injunction hearing because the Delhi High Court held that it's not in public interest to curtail the sale of this product, the interim stage, because patients are already on it, right? So if suddenly the price of the drug goes up, patients are going to suffer. Perfectly reasonable decision. And that trial wrapped up in about 6 years. It took 6 years, right? And in 2013, you had a final decision which went on appeal. And in appeal, the court confirmed there was injunction and got Cipla to pay. Cipla and Roche finally settled the matter for an unknown sum. But it takes that long, right? Even in a case where you have various protective measures put in place and courts really want you to wrap it up quickly, because there are experts involved, it can get dragged on. So right now, in the Delhi High Court, we spent a lot of time trying to figure out what is a easy, quick way to arrive at a reasonable timeline for a patent litigation. And the Delhi High Court has these proceedings called the hot tubbing proceedings, which is basically that the experts of both sides land up in court and they are asked questions by each other. So the judge just observes it, and that wraps up the whole case instead of you going and cross-examining the defendants, cross-examining the plaintiffs. So courts are trying to expedite it, but it's still not, it's not fully there. And usually what courts do is they are too overburdened to actually record the cross-examination by themselves or through the judicial officers. So they appoint lawyers as local commissioners, and the role of the local commissioners is to basically sit and note down question, answer, or have the stenographer type it. So local commissioners are used frequently in patent litigation, but again, in my experience, it doesn't significantly cut down the time taken for trial. And even when you finish trial, a lot of time is spent getting the court to finally hear your matter. So we calculated that in about, since 2000, we're doing a study from 2005 to 2020, we've had only about 140 patent decisions after trial in the whole of the country, okay? So in 15 years, 140, so that's not even 10 a year, okay? Is it? Yeah, it's not even 10 a year. So that's the reason that there is this huge apprehension around patent litigation of being a patent practitioner, is because it can be a frustrating journey. But courts are putting in place mechanisms for you to expedite it. So the other thing you can do on day one when you don't get an injunction is what they were doing in the standard essential patent cases. I don't know how many of you are familiar with SEPs, but standard essential patents are, for example, take in the case of mobile phones. There's a standard essential patent is a patent that has to be violated if you have to comply with the standard, right? So mobile phones have certain standards that the mobile phone has to be able to connect to the tower, right? So there is a mechanism there. Now that's covered by a patent. So if I need to make a mobile phone, I have to violate that patent. I have no choice, because that patent is covered by the standard in the that is required by law. So what the standard essential patent litigants were doing was that you're saying, okay, fine, you don't want to give us an injunction because this person needs to continue manufacturing phones, so be it. But ask them to deposit some money in court. So that was the other route that they were taking, that please let them deposit 5 rupees per mobile phone they're making. And then tomorrow, if I win, I get the money. Otherwise, it goes back to them. Now, this is another way in which you can get defendants to pay up. And it does dissuade people who are just in this litigation for speculative reasons, who are just seeing, let's see how it goes. So in standard essential patents, this deposit of royalty method has been pretty effective. So these are some of the options that you can consider. Now, to go back to the question about what is the difference between damages and rendition of accounts. So damages is a lump sum payment, and damages are based on facts that are within your knowledge, right? So you know that your hand sanitizer has not sold the usual amount because of the infringing product. So one is, what is your lost sales? If you lost 2 crores worth of sales in that period, that can be used. That's a fact within your knowledge. You can use that to compute damages. The second thing is their profit, right? So you're saying, fine, I haven't lost anything, but that profit they made, 1.5 crores, that could have been mine, right? Or if some third party wanted to license my patent for that period, I would have charged 50 lakhs for the license. So lost profit, reasonable royalty are usually the basis on which you calculate royalties, calculate damages. It becomes more complicated when your product is just one component of a larger system, right? Suppose I'm selling a mouse for a computer. Nobody's going to, I mean, the market for just a mouse is not as much as for a whole computer system. So if a whole computer system is sold for 50,000 rupees, I will need to apportion the value of this mouse to that computer system in arriving at a reasonable royalty, right? So I can't say that my royalty will be calculated on the computer system because there are other components to the computer system which we also have patents. On the other hand, courts have held that without a mouse, you can't have a computer, right? So the whole value of the computer is actually attributable to the mouse. So I am entitled to a share in that. So damages are usually calculated based on the facts in your knowledge, where you arrive at a particular figure, you pay court fees, and then it's smooth sailing from there. The difficulty with rendition of accounts is it becomes a 2-stage thing, right? Because what you do first is you prove the rate that you're entitled to. I am entitled to 50 rupees per computer, right? That is what you'd say up front. And then later you will have to get into the inquiry of how much did they actually sell in the period from the filing of the suit till the end. So you have these 2 routes open. Rendition of accounts is good where you generally don't have knowledge and you do have the, you don't mind going through their accounts, or you actively want them to produce their accounts. But you can make this choice later. Upfront, always include both damages and rendition of accounts. As and when you get a response from the defendants and as when the matter progresses, you can always choose one of the 2. So yes, I think I've covered the major points that I wanted to cover. So I'm just going to recap quickly and then I'll take questions if there are any. So first is, like I mentioned, please tell a story. In the plaints that I got, there was one that was prepared by a lawyer colleague, Asta, which of course, she has the benefit of practical experience. So she had identified the way to jazz up the plaint and tell a story. Very, very important, tell a story. You are not mechanically narrating facts. This is not a moot court, right? You have to build around the facts. That's very important. Second is you have to disclose all material facts. I've already mentioned that, and most of you have done that by just reproducing the hypothetical. That's one way to do it. But to chronologically arrange the facts is also important, so that it fits the story that you're trying to tell, which is that in 1978, this was a family-run company. In 1985, you designed lacs, you invented soap. In 1992, you invented this. There's a kind of history and there's a kind of telling, because what you're trying to do is to center stage the innovative part of your client's work. That's important when you're talking about the background for background for this patent. Because when you look at this patent, really, you're like, really, this is going to be subject to a patent dispute. What is there in this? It seems so common sense, right? And that's the common sense argument is the other thing you have to overcome in patent litigation, because people will be like, of course we knew it. Because when a defendant files a counterclaim saying your patent was so obvious, really, was there anything to it? You will have to say, it seems obvious in hindsight, right? But it was not obvious on the day that I invented it. In fact, you'd be surprised that the knitting needle, right? The threaded needle, the eye of the needle used to be in the middle of the needle, right? There was a guy who thought this makes no sense. I'm going to move the needle, eye of the needle to the tip. And he got a patent for that, right? And today it seems so obvious that a needle should have an eye on the top, not in the middle. right? But it wasn't obvious on the day that he invented it. And that is what is relevant, that today in any revocation proceedings, and 99% you will invite a revocation proceedings of your patent under section 64 when you file a patent infringement lawsuit. But the most important thing is obviousness and anticipation by prior disclosure, which is that somebody already said this many years before your patent. These cannot be done as a hindsight analysis, right? You have to look at the knowledge of a person skilled in the art on the day of the patent, right? So that's what I mean when I say you have to come up with a story that as on the date of this patent, this was groundbreaking, right? This was game changing. This just made everything completely different. So it's very important for you to focus on the innovative aspect, because that really is at the heart of patent law and certainly at the heart of patent litigation. Then I also mentioned to you that you need to anticipate and close out the main defenses. The main formal defenses are on non-joinder, limitation, jurisdiction, sometimes on valuation, but these are important defenses for you to close out. Please always have proper letters of authorization from your client to the signatory. You'd be surprised at how many litigations get defeated because a company has not properly authorized the guy who's signing it, right? So very important to satisfy the formal requirements and to basically have a map of what is it that you expect will happen. So be critical of your case before you start it. Try to anticipate what's going to happen in court. So that was my first part. The second part is, I've already mentioned to you that there are two kinds of parties: necessary parties, proper parties. Necessary parties are parties without whom there can be no adjudication of the dispute. In this case, the only necessary party is Invido. Baba Bimp is also necessary because you cannot file a separate case against Baba Bimp if you don't add them into these proceedings, right? So either you give up Baba Bimp and you forget, you condone whatever he's done, or you add him into this suit. Jacinda she's not a necessary party, she's a proper party, okay? Then I also mentioned the prayers, permanent injunction, damages, rendition of accounts are what I'd recommend. I've mentioned the jurisdiction. Make sure that your valuation of the plaint is above the pecuniary jurisdiction. Please make sure also that your jurisdiction, territorial jurisdiction requirement is met. Territorial jurisdiction in a patent case, you can only file where the defendant resides or carries on business, or where the infringing product is sold. So only one of these three places you can file a suit. So bear in mind both territorial and pecuniary jurisdiction. As far as damages are concerned, exert in proving damages and showing knowledge of the defendants for what it's worth. Your claim comparison is the heart of your claim. Spend time on, really working through what are the individual ingredients of the claim and how these are satisfied. Get an expert report, get an expert affidavit, preferably with your claim, which will prove that this product falls within the claims set out. The comparison, please remember, I say again and again because this mistake happens a lot, is between the claim of your patent and the product. It is not between product and product. Claim versus product, bear that in mind. Equivalence, again, you'll have to spend time when you're arguing equivalence saying that the use of glycerin was not your inventive step. Use of glycerin is completely irrelevant, right? Glycerin is like a non-issue as far as you're concerned. The inventive step for you is how the alcohol comes together with the isopropyl alcohol and also with the other components. But glycerin being replaced by coconut oil does not affect your inventive step, and therefore this is a trivial variation and it should still amount to infringement. And bear in mind the importance of the formal paragraphs.
Ma'am,
yeah.
I had a doubt regarding damages. I was unmuted right now. If I can ask right now, should I ask at the end?
Go ahead.
Okay. My doubt was, ma'am, is profit disgorgement a very remedy that's frequently allowed to the plaintiff?
Sorry, what?
Profit disgorgement of profits.
What is that?
So, ma'am, essentially, if X has a patent over a product, but Y infringes that patent and sells that product in volumes that X never could, much more than what X could ever, is X still entitled to all the profits that Y made by infringing that product, even though it could possibly never have on its own sold that much of that product?
So, this issue frequently arises where the inventor is an individual, right? So I have currently represent 2 individuals. Now they have never been able to market their products, right? Because to manufacture products, you need industrial setups, right? So in this situation, what is a way to compute royalty? You will need to do some market research to see, or you will have to get evidence from the market saying, for a product of this nature, this is the applicable royalty rate. So I would go down the reasonable royalty method rather than the profits, because in the loss profit method, you will need to show that you had the ability to make it. Or even if you don't show it, the other side can always create doubt on the basis that you never had the ability to make it. So what are you talking about? You never made these profits. In fact, in my client's case, we've never made even a single piece of the product. It's just that our patent was given to these people and they have now gone ahead and made it. So in that case, I would use a reasonable royalty percentage rather than loss profit.
Okay. All right.
There's another question.
Yes, ma'am. So Samruddhi has asked again. She was wondering whether you could tell the arguments that the defendant could make in this same fact scenario.
Oh.
1 second, sorry for the confusion. Yeah.
Okay. So as far as the defendant's arguments are concerned, first is that, I mean, if I take the plaints that have been sent to me, then it's straightforward. Delhi High Court has no pecuniary jurisdiction. The relief is all undervalued. Okay. Second is that glycerin and coconut oil are not equivalents, right? They actually are different chemical compositions, and by replacing glycerin with coconut oil, I've escaped the claims. I'm not even an infringing product, right? There is no infringement at all, whether literal or by equivalence. So the main arguments for the defendant would be that I am actually not, your patent is limited to these 4 components which have been set out in the claims. You can't now go and claim everything in the world. And the other defense which defendants often take is something known as a Gillette defense. What is a Gillette defense? Gillette defense is that I'm not infringing your patent. I am infringing a patent that has already expired, right? So, for example, if they are able to produce another sanitizing composition patent that expired last year, which includes coconut oil, right? They will say, my patent is actually different. My product is different from your patent. In fact, my product is covered by a patent which has lapsed, right? So Gillette defense is a very popular defense, as is non-infringement. So the 2 defenses I would take is A, glycerin and coconut oil are not equivalents. The minute I replace glycerin with coconut oil, I'm outside the scope of your claim. The second defense I would take is a Gillette defense, which is that I am infringing an older patent which also envisions the use of coconut oil in a hand sanitizing composition. Other than that, there will be that this patent is obvious. There's nothing new or novel about this. You have gone and combined some random ingredients and gotten this patent. But there is nothing new, novel, non-obvious. And if you go through section 64 of the Patents Act, it gives you all the grounds you need to mount a challenge to a patent. So a section 64 counterclaim is almost 99, like I said, 99% chances are that you will encounter a counterclaim. So that would be those would be the main defenses.
Thank you, ma'am. We have one more question from Astha Sharma.
Yeah.
Astha, you can go ahead.
So, hello, can you hear me?
Yeah.
Yeah, so Swathi, I just wanted to know what is the good practice to have a crisp plaint or the longer one? Like I have like a lot of facts to put in would be the great idea, or keeping it short and only the facts which are most relevant that I should put in plaint. I was confused while drafting like what all I can write, or should I limit it to some facts only? I just wanted to know that.
So generally, my personal preference is to keep plaints short, because I find that people's attention span is short, right? But
yeah.
there are 2 dangers. Now, the first danger is under the Commercial Courts Act, the rule for pleadings and evidence has become very strict. So what you don't say upfront, can you introduce later? It's a big question mark, right? The second is, I think it's okay to err on the side of excess while you're describing the invention, right? because actually for a lay judge, and bear in mind that all the judges who hear your infringement cases don't have a technical degree, right? For them to understand what this composition or what this invention is, it's okay to spend more time rather than less. I would say you can reduce or be more conscious of editing your pleadings in the paragraphs after you describe the defendant's infringement, but do spend significant amount of time describing the inventive step and the innovation behind the invention.
Okay. And I have one more question. So while writing the valuation, what do you suggest? Should we put all the values we think we can render, or we should keep it like for future? Like we can even amend our valuation in a future. Like what is the best practice of keeping the valuation part?
So you
Like
know what most people do, and I don't see any reason to differ from it, is that give the basic value that is needed for you to pay court fees, right? And so if you're if the Delhi High Court has 2 crores pecuniary jurisdiction, you pay court fees on 2 crores, and you say, as and when I find out, I will enhance my claim, right? That's one way to do it.
Okay,
The other strategic way, and there is another strategic way, is that people want to scare off defendants, right? So if they see a 10 crore claim, are they more likely to settle? So some people, you'll notice if you read the news, 100 crore defamation suit filed, right? So there are people who adopt that tactic as well. You want to scare off a defendant into thinking that you're going to, make them bankrupt. Yeah, people adopt. People would then enhance their damages claim. So this is the one of the 2 routes. I have so far usually said that let me just do the 2 crores and then figure out how much more I'm due, and then pay excess court fees and then prove it. But please bear in mind, but both damages, for damages, you will have to prove damages. And that's, I think, the major weakness in patent litigation as it exists. Nobody proves damages. They say I'm owed 2 crores, but you need to get to very granular detail on how you arrived at 2 crores, right? Because otherwise you're not going to get.
Okay, thank you. And I have a last question. So have you ever seen, like in India, do we have doctor of equivalence infringement, like coconut and glycerin? So we, like in US, we can do doctrine of equivalence, like both are equivalent.
We have a case from 1978 on doctrine of equivalence, Raj Prakash versus Mangatram. So doctrine of equivalence is very well recognized in India.
Okay, okay. Thank you, Swathi. So those were my questions.
So I have other 4 questions, right?
No, ma'am, right now, I think all the questions are almost done.
Okay.
We've answered the 4 questions.
Okay. So then I'm going to wrap up. So this was my advice to you, that on a practical, lighter note, I mean, patent litigation is really among the most fascinating branches of litigation. I simply love it. And I've been doing it for 15 years. And even today, when I get a new patent case, I'm really, really super excited about it. The challenge that you're going to face is that, please remember, you're appearing before lay judges, right? So your job as an advocate is really to process all this complicated information that you're getting and to make it simple, make it easy for somebody to understand. So last year I had the opportunity to argue this matter before the Karnataka High Court, and halfway through my arguments, it was before a division bench, one of the judges nearly fell asleep, okay, because I was talking about gelatinization of maida, okay, and he could not be less interested. So these are the kind of challenges that you're going to face. So one is use new media like PowerPoint presentations, right? Simplify things, but don't make it stupid. Because often what happens is when the judges really oversimplify some technology, they actually don't, you get bad law. So to make it both simple, but at the same time accurate is your main job as a lawyer. Second, focus on presentation. Presentation is everything. So when you present complex technology before the bench, consider using PowerPoint, consider using videos to explain what is it that lies at the heart of the invention. Because if you just set out the claims, nobody is going to think that this is anything worthy of protection. And it's only when you work with scientists, you work with people who know the technology behind it, you will understand the beauty of each patent. And when you understand, you will be able to better communicate. But there is a huge distance that you need to travel between understanding the technology and being able to effectively communicate. So that, it's not just, this is just the paperwork. After this, you have 200% more labor that you need to put in to be able to put it in the simplest possible terms. I had one question.
Yes, ma'am. One participant is just asking if we could provide a copy of the ideal plaintiff for this problem. I can share it with all the registered participants if we have.
Yeah, sure. I mean, I like to draft it, so I'm feeling lazy. But you know what might be better is that person just drafts and sends it to me, and I can correct. I'd be happy to do that. Anybody can email me at any time on once they've drafted a plaint, because ideal plaint I can mark up their plaint and send it back. I'd be happy to do that.
Thank you so much, ma'am. Thank you for that brilliant session, and for really stressing upon the point that we need to develop a story while in a patent litigation, and the way that we have to communicate all the complicated information into simple, accurate, yet an attractive manner. I'm sure everyone interested in patent litigation would surely keep these points in mind. With that, thank you so much for the lecture.
And I just want to say one more thing, which is that bear in mind there aren't so many people doing good quality patent litigation. You want to get into it, I strongly encourage you, do it. IP litigation is so interesting. It's so much fun. I mean, I don't have any other words to use, but fun. I mean, if you need to be involved, if you need to find the steam to go through this profession, it's long, right? Your career is going to be 35, 40 years. Now, what's going to keep you up at night and get you to wake up in the morning and go to work? It's something you love. And for me, I do it because I really, really love it. And I really think there is a lot of stuff here that you can do even without a technical degree. I did 11th and 12th, science in 11th and 12th, but I don't have a science degree, despite which I find it endlessly fascinating, right? My first patent was on the water purifier technology. And it was so interesting. It's such a simple patent, but there's so much thought that goes behind designing technology. And now with artificial intelligence, you have a whole host of like really, really interesting patents. So I really encourage all of you to think of patent litigation and IP litigation as a very, interesting, lucrative, fun career choice. So thank you.
Thank you so much. Thank you to all the participants who joined, and especially the people who sent their draft plaints. Thank you for this brilliant session. Thank you.
Bye.